5 seconds to go. Start. Where averments regarding execution of sale agreement made by vendee in plaint is not disputed by vendor in his written statement, then it cannot be said that the agreement is not agreement of sale but is invitation to offer. On February 19, 1984, the vendor entered into an agreement of sale with the vendee in respect of a tiled house consisting of 6 rooms, veranda, 3 mulgis, upstairs portion consisting of 1 room, hall and veranda inclusive of 1 room, hall and veranda inclusive of entire area pertaining to the house along with the entire vacant site situate in door number 9.118 bearing assessment 116 at village Payakaropet, district Vishakhapatnam for consideration of rupees 1 lakh. The vendee paid rupees 10,000 in advance and the remaining consideration of rupees 90,000 was to be paid at the time of execution and registration of sale deed. This vendor in the agreement represented that he was absolute owner of the property. On March 24, 1984, the vendor's wife sent a notice to the vendee as well as vendor calling upon them to cancel the agreement as she held half share in the property having developed upon her on the death of her son K. Apala. She stated in the notice that she was not willing to sell her share and was ready to purchase the share of the vendor, her husband. On March 28, 1984, the vendee replied to the notice sent to him by vendor's wife and asserted that the agreement was binding on her and the notice has been given in collusion with the vendor. On March 30, 1984, the vendee sent a notice to the vendor calling upon him to receive balance sale consideration of rupees 90,000 from him and execute the sale deed along with his wife as per the terms of the agreement, failing which he may be constrained to initiate action for necessary reliefs. On April 21, 1984, the vendor sent reply to the vendee's notice dated March 1984 informing him that he was unable to execute sale deed in the vendee's favor and he may take back sum of rupees 10,000 that was paid in advance. The vendee then filed a suit for specific performance of the agreement against the vendor and his wife. He prayed for a direction to them to execute sale deed as per the terms of the agreement and got it registered after taking the remaining sale consideration of rupees 90,000 and if they fail to execute the same as per the directions of the court, then court may execute the sale deed after the vendee deposits the balance sale price within the time allowed by the court. In the alternative, the vendee prayed for refund of the advance amount along with interest. The vendor and his wife filed separate written statements. The vendor's wife mainly set up the plea that her son died intestate and she succeeded to his share and her husband is not the absolute owner of the property and she was not willing to part with her share and she has already asked her husband to sell his share to her. The subordinate judge Anakapalli, in light of the pleadings of the parties framed issues and after recording the evidence and hearing the parties decreed the suit. The vendor's wife being not satisfied with the judgment and decree dated July 2, 1991 passed by the subordinate judge preferred first appeal before the High Court. The High Court did not accept the plea of vendee that vendor had implied authority or that vendor's wife was estopped from raising the plea that the agreement did not bind her. The High Court finally held that the agreement of sale, although covered the entire property, but as the vendor had only half share and interest in the property, the decree for specific performance could only be granted to the extent of the vendor's share in the property. The Supreme Court held the decisions of High Court right, and Wendy had right to apply for partition of property and get share demarcated only after sale deed was executed in his favor. Stop.